Good evening, friends. This is the sixth video on law of evidence, and today we are going to do with an important part of the law of evidence. It is circumstantial of evidence. As in part 5, we have seen what is evidence, what are the various types of evidence. In continuity, we have to see what is meant by circumstantial evidence. Now, many a times short notes have been asked on it. Remember, friend, in this short note, we have to cover all the dimensions related to the topic to the extent we can. Now, we will study in depth the concept of circumstantial evidence, and I will give you a brief overview of what we are going to discuss in this video. One is that we will see a definition of the circumstantial evidence as to what is circumstantial evidence. Second, many a times it is asked in preliminary examination, is it secondary evidence? That is, are circumstantial evidence type of secondary evidence? Then we will see the principles to be followed while dealing with the circumstantial evidence. What are the principles which have been laid down by the Supreme Court while dealing with circumstantial evidence? Then we will also see an important question, that can conviction be solely on the basis of circumstantial evidence? We will also see its importance and limitations while critically analyzing the concept of circumstantial evidence. And finally, we will conclude with certain uh, derivative about what all we have studied in it. So let us begin. First, we will see the definition. Friends, the simplest definition of circumstantial evidence is that it is evidence based upon surrounding facts. Those facts which are surrounding the main fact. Evidence based upon surrounding facts from which definitive inference can be drawn regarding existence or non-existence of certain facts. So these are not the fact itself, rather these are the surrounding facts, surrounding circumstances, but such circumstances from which certain definitive inference can be drawn with regard to the main aspect or the main fact. Then, is it secondary evidence? Friends, no. It is not a secondary evidence. Rather, it is said that it is direct evidence applied indirectly. Now, what are the principles to be adhered while dealing with secondary evidence? We will discuss two important case laws in this, and then we will also find out the basic crux of all these decisions. In state of UP versus Ravindra Prakash Mittal, this was an important case, and in this 4 points were laid down. One is that circumstances from which the conclusion is drawn should be fully established. So the circumstances from which the main fact is drawn, those circumstances should be fully proved. Then the circumstances should be conclusive in nature. That is, it should give a definite conclusion. It should not create any confusion in the mind of the judge. Third is that all the facts so established should be consistent only with the hypothesis of guilt and inconsistent with innocence of the accused. So all the surrounding facts, all the surrounding circumstances which are proved should be consistent with only and only one hypothesis, and that hypothesis should be the guilt of the accused. Then the circumstances to a moral certainty exclude the possibility of guilt of any person other than the accused. So there should be a certainty. What certainty? That the person who is accused has done the crime, and it should totally exclude that any person other than the accused has done the crime. Now, one more to it, these four were again emphasized, and one more to it was there in Hanumant Govind Nargonkar versus State of MP. Friends, this is very important case, landmark case on Evidence Act and on circumstantial evidence. So, in case you are asked in examination, please do mention it. And in prelims also, many a times questions have been asked based on this case law. Now, in this, one more thing was there, that there must be a chain of evidence, so complete as to leave as to not leave any reasonable ground for conclusion consistent with the innocence of the accused. To be brief, that there should be a complete chain of evidence that should point to the guilt of the accused. Now, we will drive the 5C theory based on these two decisions, that there should be 5Cs. What? That the circumstantial evidence should be conclusive in nature. Conclusive means that it should be fully established. These circumstantial evidence which lead to the proving the direct to the main fact should be fully established. They should be fully proved. Then they should be consistent throughout. There should not be any anomaly. There should not be any ambiguity in the whole story. Then there should be a complete chain of evidence. There should be no missing link in the whole circumstantial evidence. Then it should be circumscribed in nature. Circumscribed in nature means that it should only lead to one hypothesis, and that hypothesis should be the guilt of the accused. It should not point to any other hypothesis, any other possibility that can lead to the innocence of the accused. Then it should be cumulative in nature. Cumulative in nature means that not only one single, that is, if this is the main fact and these are the surrounding facts, then we should not be very selective as to choose only this one. Rather, we should see all the other circumstances, and based on the totality of the circumstances, inference should be drawn. Basically, if we come down from these 5 points to two, or derive 2 points from these 5 points, then we can say that it should be conclusive in nature. Conclusive means that it should fully conclude, it should fully establish the guilt of the accused. And it should be exclusive in nature. Exclusive in nature means that it should exclude any other hypothesis rather than or other than the hypothesis of guilt of the accused. So these are the 5 main things which are to be seen by the judge while he is giving any decision based on circumstantial evidence. Now, another important question is that, can conviction be solely it's not mainly, it's solely on the basis of circumstantial evidence alone? Suppose there is a case, and in that case the only evidence is circumstantial evidence. Can conviction be solely based on it? Friends, in Umedwai versus State of Gujarat, the answer to this question was given in affirmative, that yes, conviction can be solely on the basis of circumstantial evidence alone, provided, but there are certain limitations to it, provided that there is no direct evidence, and provided all these 5 basic things are completed. That is, it is conclusive in nature and exclusive in nature. In another landmark case of Lakshman Nayak versus State of Odisha, in this case, the brother, one of the person, what he did is that the accused he raped and killed the daughter of his brother. And the daughter was only 7 years old. And in that case, the only evidence was circumstantial evidence. But it was conclusive and exclusive in nature. And therefore, the court convicted the accused solely on the basis of circumstantial evidence. So, conviction can be solely on the basis of circumstantial evidence alone, provided it is conclusive and exclusive in nature. Now, we will critically analyze the concept of circumstantial evidence by seeing its importance and by seeing its limitations. One of the importance of the circumstantial evidence is that it comes to a great rescue. It comes to great help when there is lack of direct evidence. Friends, there are many cases where we do not have direct evidence. As you can see that even in the statue of justice, the lady is blindfolded. So there are many times when we don't have any direct evidence, and at that time, circumstantial evidence helps us to provide justice. Similarly, another thing is that, as we have already seen, that facts are of two types. One is internal fact and another are external facts. External facts are those facts which are perceived by our senses, while internal facts are those facts which are based on the things of which a person is conscious of. That is, these are psychological facts, these are mental facts. For example, intention, knowledge. So how do we find out intention? How do we find out the knowledge? There is no way by which we can break open the mind of the accused and see that what the intention is. In that case, that internal facts are proved by circumstantial evidence. So it is very important in cases where there is lack of direct evidence, and also it is important in proving of the internal facts. However, there are certain limitations of it, and one is that fallibility of inference. Friends, suppose this is the main fact and these are the surrounding circumstances. Now, based on these surrounding circumstances, we are making a judgment. Now, this judgment is certainly then highly subjective in nature. The judgment or the conclusion or the inference which is drawn by one may vary from the other. And that is why it is that there is fallibility of inference. That there may be cases where the inference drawn is not correct. Now, how do we remove that problem? Friends, that problem can be removed by reliability on independent facts supporting it. That is, if these circumstances and the conclusion which we draw from it are supported by independent facts, then that inference or fallibility of inference or the possibility of fallibility of inference can be reduced. Now, another problem is that is the danger of conjecture or suspicion taking the place of legal proof. That is, the suspicion, the conjectures, the preconceived notions will take the place of legal proof if proper law or proper principles are not applied while evaluating the circumstantial evidence. And this was also in form of a warning given by Baron Alderson in Reg versus Hodge. I would just like to quote it because it is very beautiful quote where he says, "The mind was apt to take pleasure in adapting circumstances and even in straining them a little." Friends, adapting circumstances, these all are what which adds to subjectivity to the circumstantial evidence. and even in straining them a little, if need be, to force them to form part of one connected whole. And more ingenious the mind of individual, the more likely was it, considering such matters, to overreach and mislead itself to supply some little link that is waiting to take for granted some fact consistent with the previous theories and necessary to render them complete. That is, what happens is that the cognitive sense of the judge may overreach, may be misled to supply some little link. I told you that there should be complete chain of event. So if there is a missing chain of event, objectively one should look at it. But many a times it happens that the mind overstrains itself, overreaches, and is misled to supply that missing link itself rather than from taking it from the circumstantial evidences. Now, how to remove this? This we may call it to be judicial indulgence. That can be removed by following the principle of natural justice, that is, the principle of judicial neutrality. A judge should be a neutral judge. Now we will see. So we have seen the limitations. Is that one limitation of it is that fallibility of inference because of subjectivity involved in it, and another is that the danger of conjecture or suspicion taking the place of legal proof. Now, what are the examples of the circumstantial evidence? One most important example of circumstantial evidence is last seen theory, that if the accused and the deceased are last seen together, and from the circumstances it is seen that he was the last person who was with him, and immediately thereafter he was found dead, then in that case it may be inferred that he has killed. But that must be supported from the circumstantial evidence, from the independent circumstances, from the independent proofs, independent facts. In Prem Thakur versus State of Punjab, same was the case, that the accused and the deceased were last seen together the previous night. But it was not supported by any other independent evidence that the accused has killed the deceased, and therefore it was held to be not sufficient for conviction. So, even in case of last seen theory, if it is not supported by independent facts, it is not corroborated, then certainly that will not be sufficient for conviction based on circumstantial evidence. Now, I will give you one example of circumstantial evidence. For example, suppose there is a village, and that village is quiet, means that not many vehicles are passing through it, roads are mostly vacant, and one villager, he is having a lorry, and normally he parks it in a ground and goes to his village and sleeps there. Now, one night, a dead person is found, or a deceased is found on the ground where the lorry is normally parked. And it is found that that night, the villager who was the driver of the lorry had actually parked the lorry there. There is also evidence that body was the body of the deceased was dragged by the vehicle to a certain extent. The visibility was all right that night. Then it may be inferred from these circumstances that in most probability it is this lorry driver who has caused the accident. Now, based on it, we will just have a conclusion. Please, friends, mention the conclusion, or in last two lines of your answer you should always write the conclusion. This is the most important part, and numbering or the marks is given based on what you conclude from it. So what we can conclude from the things we have seen is that circumstantial evidence is good, very good, but provided that it is maintained, a neutrality is maintained rather than judicial indulgence. and they are corroborated by certain independent facts, because it is what which is used to prove internal facts and also to deal with cases where there is lack of direct evidence. However, it is highly dangerous if it is proceeded with preconceived notions. That is, if there is lack of judicial neutrality, if there is lack of independent corroboration. So that is all for today, and we will just have a quick recap of all that we have done in this session. So we discussed about circumstantial evidence. A definition was seen that these are the surrounding facts from which a definitive inference can be drawn regarding existence or non-existence of certain facts. Are they secondary evidence? No, they are not secondary evidence. Rather, they are direct evidence which are applied indirectly. Then what are the principles to be adhered in the state of UP versus Ravindra Prakash Mittal, and in Hanumant Govind Nargonkar versus state of MP? It was seen that 5C theory comes up, that it should be conclusive in nature, it should be consistent throughout, complete chain of evidence should be there, it should be circumscribed in nature, that there should be no other hypothesis, it should be cumulative, that is, all circumstances should be taken together. That is, there should be a conclusive proof and there should be exclusive proof. Now, can conviction be solely on the basis of circumstantial evidence alone? In Umedwai versus state of Gujarat and in Lakshman Nayak versus state of Orissa, in both the case it was held that yes, the conviction can be solely on the basis of circumstantial evidence, provided it is conclusive and exclusive in nature and adheres to these 5C principles which we have laid down. Then, well, critically analyzes it, we have seen its importance, that where there is lack of direct evidence, it is an important piece of evidence. Then, even in proof of the internal fact, circumstantial evidence comes to great rescue. However, it suffers from certain limitations, and one limitation is that fallibility of inference because of subjectivity involved in it, and that can be removed by relying on independent facts which are supporting it. Another danger is that of conjecture or suspicion, that is, preconceived notions taking the place of legal proof. And Baden Elderson in Reg versus Hodge has already stated it that in certain case mind may overreach and mislead for going to overboard in making the chain complete where even it is incomplete. That is, that there may be judicial indulgence. And how to remove it? One can remove it by following the principle of judicial neutrality rather than judicial indulgence. One example of circumstantial evidence is last seen theory. However, last seen theory should also be corroborated and should be objectively verified. In Prem Thakur versus State of Punjab, last seen theory was not found sufficient to link the accused with the deceased. Then we have concluded it that it is good and an important evidence provided it is done neutrally and corroborated with independent facts in order to prove the internal facts and also in order to prove those circumstances where there is lack of direct evidence. However, it is dangerous if it is preceded with preconceived notion. Thank you so much, friends.